Andrew Isaac's Law are family law specialists. Family law can cover everything involving the starting of relationships, such as prenuptial agreements, adoption of children, or the ending of relationships such as divorce and separation agreements. All too often, children are the unintended victims of any dispute between their parents. The law is actually very clear on children matters in that children have the right to have a relationship with both parents. It is very easy for arguments over children to become the place where parents can put their anger about the ending of the relationship, and this inevitably means that the children suffer. Where parents cannot agree how their children should share time between them, then it is possible for either parent to apply to the court. But this should be avoided if at all possible, as it is much better for parents to agree arrangements rather than having them imposed upon them. The starting point should be to try and agree a parenting plan. There are plenty of parenting plans available, including information on the CAFCAS, Children and Family Court Advice and Support Service website. If that cannot be agreed, then it may be that a family mediator will be able to assist. Mediation is a way of having a supportive referee to sit with you whilst you try and talk things through. If mediation is not possible, then the last resort is an application to the court, which is done by using a court form C100, and the cost for this is £215. In order to complete the form, you will need a certificate to confirm that you, the applicant, have attended a mediation information and assessment meeting, MIAM, with a family mediator. Sending the form C100 to court, filing the application, will trigger an initial investigation by CAFCAS, who will check on any history of referrals to social services, criminal convictions, and a CAFCAS officer will have a telephone conversation with the parents to identify what the issues are. If there are issues which impact on the safety of the child, safeguarding issues, then the CAFCAS officer may well recommend that a Section 7 report is prepared. This will involve the children being interviewed if they're old enough, or at least seen with their parents. Schools will also be asked for a report so that the CAFCAS officer can make recommendations to the best arrangements for the children. There is a great deal of confusion about how old a child has to be before they can choose between their parents. In fact, no child should ever be asked to choose between their parents. And when they are, the wish to please the parent doing the asking means the answer is unlikely to be a true reflection of the child's feelings. The courts do try and consider the child's wishes. Generally, whilst children under 8 are spoken to, they are usually not able to understand the long-term consequences of their choices, so their wishes are of less weight. In the age group of 8 to 12 years, their wishes are sought but may not be followed. Once a child is over 12, it would be rare for the CAFCAS officer to recommend that the court go against their wishes, simply because children tend to vote with their feet if they're not happy. There are a number of hearings in the process. The first is called a First Hearing and Dispute Resolution Appointment, FHDRA. The idea being to see if the parties can resolve their issues and reach agreement at the first hearing. Indeed, the whole aim of the process is to try and enable and encourage the parents to reach an agreement, because an agreement reached by the parents of the children is always going to work better than one imposed on them by someone else. If agreement cannot be reached at the FHDRA, then either a Section 7 report will be ordered, or, if there have been allegations of domestic violence, a fact-finding hearing may be ordered. If there are no safeguarding issues to involve CAFCAS and no allegations of domestic violence, then the court will order both parties to file a statement within a certain amount of time. There will then be a final hearing, at which the evidence will be looked at and a decision will be made. It can be extremely difficult at the early stages of an FHDRA to understand what is happening and to feel that no one is listening to your point of view. Remember, this is an information gathering stage, and if agreement cannot be reached, then you do get to put your case to the court at the final hearing. Andrew Isaac's Law know the system, understand how it works, and can guide you through it. Contact Andrew Isaac's Law to arrange a consultation. Telephone 01302 349 480. Email family@andrewisaacs.co.uk. Visit the website www.andrewisaacs.co.uk.